Joining me now, trial attorney and legal analyst Wendy Patrick, to talk more about the case and what's happening in court right now. Wendy, as always, thank you. Welcome. What do you make of the defense's closing argument so far that the DA did not meet the burden of proof in this case and that Cohen is a serial liar? He lied to you, the jury. You cannot trust him.
I'll tell you, Marnie, that's exactly what we predicted, didn't we? We predicted that the defense would put Michael Cohen on trial. And justifiably so. All they have now is more ammunition with which to do exactly that. Remember, not only did Michael Cohen admit lying in a variety of cases and circumstances, the defense is able to actually convince, at least that's their plan, that he lied on the stand. Now, that's because he was maybe mistaken to be gracious, dishonest at worst. But this is some of the reasons that with Michael Cohen being the one witness, the fanboy and fixer turned foe, whose latest book was called Revenge and Motive Matters when jurors are weighing credibility, for this to be really the bow on this prosecution's case, to say the least, is not persuasive. The prosecutor is going to get up and argue and say, we have much more than Michael Cohen. We'll probably see that this afternoon. But in terms of the defense closing thus far, they're playing the hand that they have, and they really have a lot of good arguments that they're making. And this is one of the ways in which they're really looking at reasonable doubt, which is the very first thing they argued, which is important because remember, they even have two lawyers on that jury.
So the prosecution has the advantage of going last. It will be the last summation that the jury hears. How big of an advantage will that be for a very complicated, complex case?
It is a big advantage, but they also have the burden of proof. Now, they put on 20 witnesses. The defense put on 2. You don't just count witnesses on either side. You know this, Marty, because obviously, defense didn't have to do anything. But having the burden of proof is very significant. In other words, it's not just a tip of the scales, it's proof beyond a reasonable doubt, and it gives them the opportunity to really fill in all the gaps that no doubt Trump's team is going to do an excellent job this morning of exposing. Most states, there's kind of a split, but New Jersey and New York and some of those other states, the defense goes first and the prosecution. But there are many states on the West Coast where the prosecutor goes both first and last in terms of a rebuttal. So it's not unheard of for them to have the last word, but it also doesn't necessarily mean that recency effect alone is going to sway these jurors because they have so much other evidence to work with. Both sides, no doubt, are right now reminding the jurors what happened because remember, they had a week off. So they're sort of getting their trial legs back, all of them, including the lawyers.
Right. And the jury's going to want to get this wrapped up before the weekend. They typically do. As they head to deliberations, how impactful do you think having 2 attorneys in that jury will be?
I think more impactful in this case than in many others because the law is so complicated. One of the things that we do as lawyers is we do legal analysis. You look at the elements, you're going to look at the jury instructions, which are going to be so important. That's what the judge is going to deliver tomorrow. And then you fit in the facts. Those lawyers will be able to, and obviously they can't substitute their own judgment because everybody has to deliberate independently, but they're going to be pivotal because remember, the defense only needs 1, much less 2, to be able to hang up this case. And many are predicting that will in fact be what ends up happening at the very end because it's so complicated and because Judge Merchant isn't requiring them to be unanimous regarding the second crime that Donald Trump allegedly wanted to cover up by the bookkeeping error or the bookkeeping misdemeanor that he committed. At least that's what their argument is going to be.
So hung jury, the highest probability based on many people's legal assessments. If that happens, they can't try it again. Is that the end of the road?
No, I mean, they could, but they have to do that analysis. Do they want to actually try this again? I'll tell you what it's going to also depend on is what's that hang. Sometimes if it's 11-1 for guilty, there's much more of a chance of the case being retried. But then when do you retry it? Do you try it, right before the election? After the election? It really will complicate not just this case, but really the chronology of the other cases that are waiting in the wings as well. Because remember, those had to take a backseat to this one. What happens now if the jury can't come to a decision here?
Yeah, they're not going to want a second swing at this. They want to get this done. Both sides would in their favor today. Wendy Patrick, a lot to keep track of. Thank you for helping us digest it.
Thanks, Marnie.